So what is this piece? It's an empirical project, and we're trying to explore how fraud and related forms of corporate misconduct are uncovered and subject to legal penalties, specifically in private venture-backed firms, large private firms. Still at the very early stage, and I look forward to your feedback. So society's been absolutely fascinated by scandal at these tech firms. Just last year, we had streaming services made shows related to scandal at Theranos, WeWork, Uber, shown here. And coming soon, you can probably expect some movie versions of FTX. We just need to have the dust settle for a year or two. It's not just the filmmakers that are interested in this, though. SEC is also quite interested. Here's the movie they want to make. The Regulator Strikes Back, starring Gary Gensler as Darth Vader. Joke aside, the SEC has, for the last couple of years, had disclosure for large private companies as part of their rulemaking agenda. Various commissioners have pointed out some of the extreme dangers that can happen with very, very large private companies having basically outside the securities regulation sphere. Not just the SEC being interested, but scholars have also expressed a number of concerns here as well. And so what's been missing so far in this whole debate is really any sort of data. The discussion has been based all around anecdotes. So we're hoping to make a small contribution in filling this in. How widespread is the problem? What's the cost to society? Are private firms more likely to commit fraud or misconduct than similarly situated public firms? Are they better able to conceal it? If detected, how is it detected, by whom, and what sort of legal penalties are involved? If I could answer all of that, this would be a truly awesome project. I can't. There's a reason why this discussion is all based on anecdote. So I need to make a few caveats here. The real problem is we can't see the denominator. We can't really see the underlying rate of fraud or misconduct. That's just unobservable. It's even unobservable, frankly, in public firms as well. So that top line, how widespread is the problem, cost to society, I don't think empiricism is going to get very far on that. What we can hopefully do is this bottom line question, which is, to the extent that some of these problems are brought to light and subject to legal enforcement, so conditional on that, who is doing the detecting? What sort of information environment is present to make this system work? And maybe if we make some additional assumptions about similarities between public and private firms, I might be able to say a little bit about the concealing of misconduct or the lack of detectors in certain spaces, but that requires a lot more assumption, and I don't want to hang my hat on that. The real guidepost for our project here is a piece that was written about 13 years ago by Dyke, Morson, Zingalis. This was published in Journal of Finance. What they did is looked at, for public companies, basically all securities fraud suits over about an 8-year period, and they tried to define who detected this, who blew the whistle. They find that about 34% of these, so they find 216 frauds in their mind, which is these survived dismissal, these were not dismissed, and they were settled for some non-trivial amount. I think the threshold was like $3 million at the minimum end. And then the question is, who brought this to light? So sometimes it's internal governance. Sometimes the board discloses voluntarily, or internal actors in the corporation bring it to light. In public company setting, you might think of that as a way to cut off liability risk under fraud on the market regime. But often it's external parties. It's parties outside the corporation that are bringing this to light. And one of the fascinating things about the DMZ study is it's a whole host of detectors. It's not one party. We have analysts, we have auditors, short sellers, each detecting some of these 216. So this required a ton of work on their part to pick all these up. Law firms aren't doing so much. SEC isn't doing very much. Media carries a bigger role than you might expect. You also see employees showing up 12% of the time in the DMZ study. Industry regulators, meaning not the SEC, are also doing some work. When we shift over from this picture to the private firm side, you'll notice, so how does this translate? I guess that's kind of our research question. And what you'll notice is some of the parties don't really exist in the private space. So we don't have analysts for private firms. You can't short sell a private company. Most of them don't have external auditors. And so I wouldn't really expect those first three groups to be doing any detecting. This next group might be able to do some, but they have some informational disadvantages. Plaintiff side law firms, SEC, and even the media, they often rely heavily on disclosures that are coming through periodic disclosure through the public company regime. And so without that information, it's hard for them to know how to start any sort of litigation, even if they have the right incentives to do so. And then at the bottom, we have, say, equity investors and employees. They may have good access to information, but their incentives are quite compromised, especially for a large private company. The employees in most venture-backed firms have restricted stock units, stock options, and this may constitute a pretty large percentage of their potential wealth. Blowing the whistle on the company is basically burning their portfolio. So there might be some limitations on their ability to act. And finally, at the bottom, customers and industry regulators. Customers, I mean to also include clients, possibly even competitors. These parties can generate their own information. They're not necessarily relying on the SEC or for periodic disclosure, and they might have strong incentives to act. And so we would expect, our theory here would be that those groups might do a fair bit more detecting in the private company space as compared to what DMZ found. I'll skip this in the interest of time. This is trying to say the last slide in a visual format. How do we go about this? We put together a couple different groups. So it's defined around a financing event. So we started with an IPO. We used JRitter's database of IPOs and matched it with venture-backed. And so from 2010 to the end of 2017, we found 402 venture-backed IPOs. For each of these firms, we collect data starting 2 years before the IPO and go out to 2 years after. So it's a 5-year bubble, if you will. One of the nice things about using the IPO firms is they have both a private life and a public life split in the middle by the IPO. Unfortunately, going public is not simply a treatment effect. It's also an event that could itself be a source of misconduct. So we have a little bit to sort through here to create somewhat of a baseline. We also look at private placements. So these are to create more of a comparable size. I looked at companies that had raised at least 200 million in venture financing and had a private placement of 100 million. These are very, very, very large. These are basically all unicorns or decacorn type companies. There were 178 of these in the 2010 to 2017 period, and we do the same 5-year window around them. And then to create a public company baseline, we use seasoned equity offerings in the same period. And I put the number of restrictions on that I could go into in the Q&A if people have questions. Summary statistics, I want to be upfront and admit these are not similar populations. The private placement group, these firms tend to be more in the software space. They tend to be actually much more sophisticated or large than their public company counterparts, which is a little bit of something that I might need to address if we try to move into regression analysis here. The IPO group has a pretty large amount of healthcare. This is partly because that's one of the few spaces that wasn't decimated in kind of the IPO for tech firms. Moving beyond this, just to make sure I'm staying on time. So how do we create a database then of detected and penalized corporate misconduct? And what we're looking at, the first piece of data we're using is the same thing that DMZ used. It's basically securities class action suits. We collect this for all the firms. The second, we're a little concerned that for private firms specifically, you're not going to see securities litigation for a variety of reasons. So we try to look for, let's call it a broader set of public-like misconduct. These might be suits brought by other regulators that are not necessarily based on securities fraud, for basically violating their industry regulator rules. We might also pick up things that are, say, consumer welfare protection suits. What we're trying to avoid, though, is purely private matter. So we're not going to include things like patent litigation or a purely commercial dispute between two corporations, but rather something that has more of a public-facing aspect to it. And we collect this through LexisNexis, and we compare this to what we found is material litigation disclosure for public firms, and it seemed to match up pretty well. Of course, there could be some errors here, but this is a kind of soft sort of data. And we also get SEC investigations. This is from Daniel Taylor. He put together a number of FOIA requests to see basically every firm that the SEC launched an investigation against. This is not quite the same thing, but it will give us some sense of the SEC's ability to look inside these private companies. We only count suits that were settled or adjudicated for a positive amount. And we'll call that legal penalty. That's basically our dependent variable here. We find legal penalties in 79 out of 880 firms. This can rise to 122 if you also include SEC investigations. They're a little bit different, so I don't necessarily sure if I want to count them together. The average settlement is about 23 million. So here's just looking at the IPO group, and you can see from 2 years pre-IPO to 2 years post, how much of this legally penalized misconduct are we seeing? We see very little in the 2 years before the IPO, about a 0.2% annual rate of any sort of legally penalized misconduct. It jumps up to about 5.6% post-IPO. A good percentage of this is related to the IPO itself, and so you see this jump of securities class action suits in year one. But it's not just that. This other misconduct is also going up. There seems to be some complementarity between the securities disclosure and the ability of other regulators to get involved, or other even state AGs, for example, to get involved. The private placement group is fairly flat, about 2% annual detection rate throughout. It's a higher rate because I think these companies are a little more sophisticated than the IPO firms. And finally, for the SEO group, we see a slight jump after the seasoned equity offering, going from about 3.5% before to 4.5% after. What if we just look at it based on just years while private versus years while public? We see kind of similar story here. Years while private, we have about a 1.2% chance of any sort of thing, and I'm including the SEC investigations here. And you'll notice the SEC, at least during our period, was completely absent from the private company space. This has started to change. They launched their Silicon Valley initiative in 2016, the very end of our period, and you're starting to see them get a little more involved in trying to solve what they admit is kind of a blind spot they had. But for our data period, they did none, or two. And for public, we see about a threefold increase in the amount of legally penalized conduct detected. I don't know how much actual misconduct is going on, so this doesn't necessarily mean there's 3 times as much misconduct. It just tells you how much detection is going on. Who's doing the detecting? Right now, I just have the IPO group and the private placement group. The seasoned equity offerings, I have the data. I just haven't been able to put this all together into a table format. But just comparing these two, we see a similar breakdown in external versus internal as what DMZ found, about 63% external, which means internally for these IPO firms post-IPO, their boards are disclosing some problems. I'll skip that right now. Employee whistleblowers, they're a big deal in the private placement group. To the extent there's any problems showing up for these private firms, the employees are carrying, as you might expect, a big percentage of the weight. The other group that's doing a lot here is industry regulators. The FDA, various other health regulators, some financial regulators are doing a lot more than you might expect. These are not SEC. And they also are able to see pre-IPO. So some of their detection is going on outside of the public company space. Who are these industry regulators? Just breaking it down. The FDA is 4 of them. State attorney generals, some foreign regulators, a couple UK healthcare agency, etc. The numbers here are tiny, so I don't want to draw too much from this. What about due diligence? You might think, well, this is large private investors. They're sophisticated. Perhaps their due diligence could weed some of this out. Maybe firms financed by elite VCs or firms that have more outside round funding would have less of the legally penalized misconduct. We don't find any of that at all. No evidence that either of the above reduces the percentage of detected and penalized misconduct. If anything, the sophisticated VCs seem to have more of these suits brought against them. It might just be that they're larger firms. It might also be something I've written about previously, that I think the VCs have a strong incentive to amplify risk. The simple takeaway on this is they're not good gatekeepers for society. If you wanted to kind of analogize them to investment banks doing underwriting work, venture capitalists are not playing the same role, and you shouldn't really expect them to. Policy implications, I think this is open to a lot of different views. Depending upon your political persuasion, you might view this and just say that's not a problem. I don't want to have a hard takeaway here. Periodic disclosure does appear to act as a complement to other channels of misconduct detection. I think that's somewhat interesting. I would also caution against regulation by scandal. Theranos and WeWork are completely unlike most of what we're seeing here in terms of scale and all sorts of other measures. So I would worry that the SEC might get a little bit ahead of itself. We hope this can shift the conversation to thinking more about how bad things come to light and the information necessary, especially on the private side of the ledger. I'll end there. Thank you.